All right, welcome to The Explainer. Today, we're going to pull back the curtain on something that, believe it or not, you probably interact with every single day. The contract. Yeah, I know, sounds a bit dry, but trust me, this stuff is everywhere. So, let's dive right in. Seriously, just think about it for a second. Have you ever promised to pay a friend back for lunch? Or, agreed to house sit for a neighbor? These are all agreements, right? But here's the big question. When does a simple handshake or a casual "I promise" turn into something the law can actually enforce? That's the mystery we're unpacking today.
So here's our game plan. We're going to follow the entire life story of a contract. We'll look at how it's born, what its life is like, how it eventually ends, and, this is the juicy part, what happens when a promise gets broken. Let's get to it.
Okay, first things first. Let's start at the very beginning. The birth of a promise. What in the world is a contract, really?
So on a technical level, the law of contract is basically the rule book that says, okay, this promise counts, but that one doesn't. It's what gives a promise legal teeth. In India, for instance, the main law for this is the Indian Contract Act of 1872. That's some old school legislation, but this is the framework, the legal engine, that takes a simple "I promise" and makes it something a court can actually stand behind.
Let's break that down into simple terms. A contract is a legally binding deal between at least two people. And here's the crucial part. Each person has to promise to do something or not do something in exchange for getting something back. It's a two-way street. Think of it like this. I'll give you this if you give me that. It's not a one-sided gift, it's an exchange.
Right, so this is super important. Not every promise you make is a contract. You can't just agree to something and automatically assume it's legally binding. To create a real, valid contract, you need to follow a specific recipe. It's got a list of essential ingredients. And how many ingredients are on that list? Well, there are 8 of them. 8 essential conditions that an agreement has to tick off before the law will take it seriously. And you need all of them, no skipping. So let's run through them real quick. You've got to have an offer and acceptance. That's someone saying, will you do this? And the other person saying, yes, I will. Then there's lawful consideration. That's just a fancy way of saying, what's in it for me? The exchange of value. The capacity of parties means everyone has to be legally capable, not a minor or someone who isn't of sound mind. Free consent is a big one. You can't be tricked or forced into it. The lawful object just means the whole point of the contract has to be legal. The terms need certainty. They can't be vague. It also has to have a possibility of performance. You can't have a contract to build a time machine, right? And finally, some contracts require certain legal formalities, like being written down and signed. Okay, so once our contract is born, it's got all 8 ingredients, it's valid, it starts its life. And just like anything else, contracts aren't all the same. They come in different flavors, different types, and they have their own set of rules they have to play by.
You can kind of categorize them in a few ways. First, how was it formed? Was it express, meaning you wrote it down or spoke the terms out loud? Or was it implied, where your actions created the contract, like hailing a cab? Then, what's its status? Is it executed, all done, promises fulfilled? Or executory, meaning there are still things left to do? And maybe most importantly, is it enforceable? Is it a valid contract? A void one that was never legal to begin with? Or maybe voidable, where one party has the option to back out?
Now, here's a classic example that trips a lot of people up. The difference between an offer and an invitation to offer. So you see a jacket in a store window with a price tag on it. Is that an offer? Nope. It's actually an invitation for you to make an offer. You're the one who makes the offer when you bring the jacket to the cashier. The store then accepts your offer. It seems like a small detail, but it's a huge deal. It means the store isn't legally obligated to sell you that jacket if, say, it was the last one and they just sold it.
And a couple more key ideas to keep in your back pocket. First, privity of contract. This basically means that only the people who are actually in the contract can sue over it. A stranger can't just jump in and file a lawsuit. Then there are these weird things called quasi-contracts. They're not real contracts, but situations where the law says, hey, that's not fair, and creates a legal duty anyway. Like, if a bank accidentally deposits $1 million into your account, you can't just keep it. The law creates an obligation for you to give it back to prevent unjust enrichment. All right, every good story has to come to an end, right? And for most contracts, it's a happy, peaceful ending. It's done its job and everyone can move on. In legal speak, this is called the discharge of a contract.
So how can a contract wrap up? Well, the most common way is through performance. Everyone did what they said they were going to do. Mission accomplished. It can also end by agreement, where both sides just decide to call it quits. Or sometimes it becomes impossible to perform, like if you hired a band for your wedding and their tour bus drives off a cliff. Yikes. Then there's operation of law, things like bankruptcy or death. And then there's the dramatic one, breach.
And this is where the drama happens. This is the dramatic conclusion. What happens when the story doesn't end peacefully? When one person just doesn't do what they promised? That, my friends, is a breach of contract.
So a promise has been broken. What now? What can you actually do about it? This is the million-dollar question, right? The good news is you're not just left high and dry. The law gives you a whole toolkit of options to fix the situation. Lawyers call these remedies.
So what's in this toolkit? Well, the most common tool is damages. That's cold, hard cash to make up for whatever loss you suffered. Sometimes, though, money isn't enough. A court might order specific performance, which literally forces the other person to do the thing they promised. An injunction is the opposite. It's a court order telling someone to stop doing something. And then there's quantum eruit, which is a cool Latin phrase that just means as much as he has earned. It's about getting paid fairly for the work you've already put in, even if the contract fell apart.
So we've walked through the whole life of a contract. Its birth, its life, how it ends peacefully, and how it ends dramatically. But let's zoom out. Why does any of this matter? What's the real legacy of a contract?
When you get right down to it, contract law is the foundation of, well, almost everything. It's what allows us to trust each other in business, and even in our personal lives. It gives us the confidence to make deals, knowing there's a legal safety net. It prevents people from being taken advantage of. Honestly, without it, our entire economy would probably grind to a halt. So now you know the rules. You know how a simple promise can transform into this incredibly powerful, legally backed tool. So here's a final thought for you. The next time you're making a big promise or a serious deal, think about this stuff. Which of your promises are important enough to deserve the full power of a contract? That's definitely something to chew on. Thanks for joining me.